You're right. I think we're ready to start now. Again, I'm Elliot Stone, your moderator. Joining me on the call will be Linda Latterman, a life care planner of 30 years and manager of our life care planning team. And we'll take questions at the end of the broadcast. Let's begin with a brief introduction about life care plans for those not familiar with them. Life care plans are utilized to maximize settlements in PI cases. Historically, they've been utilized on catastrophic 7, 8-figure cases due to cost, mostly. Most attorneys may commission anywhere from 0 to 2 or more life care plans a year. The fees typically run between anywhere from $5,000 to $25,000 per case. Many life care planners charge by the hour, bringing some uncertainty into the process as to what the final cost would be. Life care plans up till now have been used sparingly and later on in the litigation so as to preserve working capital with the hope of bringing about a settlement with expense reimbursement at the end. The much more numerous mid-range cases, your neck, back cases with continuing treatments, injections, possible surgery that are worth $100,000 and more have not warranted life care plans until now, mostly due to cash flow concerns. Our basic premise is that more life care plans mean more larger settlements. We feel that the interest-free life care plans payable at settlement is a game changer that will dramatically increase their usage along with firm profits. All right, by way of background, life care planning has grown dramatically in the last 30 to 40 years. The first reference to it was in an article written by Paul Deutsch and Fred Raffa in 1981. Life care plans have proved valuable in managing catastrophic illness and injury cases such as TBI, amputees, brain-damaged children. Its methodology has provided professionals with a consistent basis for analyzing the immediate and lifelong needs of patients necessitated by serious injuries. They've been utilized by the courts and juries to better understand the long-term effects of catastrophic injuries. So, what is a life care plan? Well, a life care plan provides an organized, concise plan for current and future lifetime medical needs with costs. It accounts for all of the medical care and rehabilitation needs of individuals with serious injuries and is usually put together by board-certified professionals, including rehabilitation counseling, nursing, psychology, physiatrists, and case managers. There's a board certification in life care planning granted by the Commission on Healthcare Certification. Typically, the plans are based upon medical records review, client interviews, recommendations from members of the current treating team, practice guidelines, and research relative to the individual's disability. So what's included in a life care plan? Well, some of the areas that are addressed include medications, diagnostic testing, wheelchair needs, projected routine future medical care, orthopedic equipment needs, projected surgical treatment, home furnishings, architectural renovations, aids for independent function, and also leisure recreational activity. Now, here we have a summary overview of two sample plans with the total cost projections at the bottom. The one on the left is a catastrophic one, and the one on the right, non-catastrophic. You can see the biggest difference between the two of these is the last line item, the home care, home services, where in the catastrophic case, it's nearly $1.5 million of the total, while on the other one, it's $9,600. Clearly on the first case, you had somebody that appeared to be incapacitated for life and would need constant round-the-clock care, hence the difference in the pricing. Now, let's focus now on the much more common mid-range cases, valued at $100,000 and up. Typically, most attorneys have anywhere from 5 to 20 cases in this range, many more than the much rarer catastrophic ones. Now, non-catastrophic cases that we feel now warrant life care plans generally meet these criteria. Minimum $100,000 case value. Plaintiff typically needs to have some continuing medical issues. The adjuster's offer, if any, is unacceptable. Adjusters will say that your client's a malingerer. Don't tell me, show me your damages. The value of lien-based life care plans really comes into play on these types of cases. Motor vehicle accidents, slip and fall, where you've got neck and back issues, pain injections, physical therapy, and possible future surgery. These are your garden variety cases. Now, let's look at these two visuals. On the left, you see an insurance policy. Policy limits, $250,000. On the right, the life care plan that was created, preferably early on in the litigation, because now you're not spending any money to pay a life care planner, so there's no reason to delay. The life care plan shows costs of $400,000, $150,000 more than the policy limits. Now, when presented to the adjuster with the life care plan, it kind of puts the adjuster in a quandary. The adjuster who was offering $25,000 to go away now is forced to increase the reserves substantially and also be concerned about a bad faith claim if this case goes to trial and the jury accepts the life care plan totals. Then he's got a problem. Now, this service we're offering gets very interesting when firm-wide there might be 5, 10, 20, or 50 or more cases that fall into this mid-range category. Then it gets interesting. Now, if there's one thing I'd like you to really study and understand, it's this chart we put together concerning actual cases that the life care plans were utilized on with the results. So we've got a sampling here when the life care plans were regularly used sooner versus later in the litigation. There's no reason to wait since there's no cash outlay. So these life care plans might as well be utilized as early as pre-litigation or with the demand letters, but certainly before any mediation. Now, what we've presented here in this chart are 8 cases. 5 of them are non-catastrophic ones, and 3 are catastrophic. And if you look at the categories, from left to right, you'll see the type of case, the cost of the life care plan, what the totals are, policy limits, the plaintiff offer, defense counteroffer, when the life care plan was submitted, how the case resolved, the settlement time frame, and also what was the settlement over the defense offer, and the additional monies for the plaintiff and for the law firm in fees. So let's just take a look at a couple of these and see what we got. On the first one, this is a PI case, motor vehicle, where the limits were $250,000, and the life care plan came across as $463,000, well above the limits, and that's what the plaintiff demanded. The defense counteroffered with $35,000, and the life care plan was submitted post-demand letter pre-mediation. It settled in mediation for $250,000, the policy limits, and that was about 7 months thereafter the life care plan was utilized. And it was 7 times what the defense had offered, and you can see the numbers there for the additional award to the plaintiff and the legal fees earned. Second case, another motor vehicle case, you have a $200,000 policy, life care plan 202, defense offer 12.5, submitted with the demand letter nice and early, settled in mediation 5 months post-demand. Here they got 16 times the offer. Third case, a more serious motor vehicle one, 500 policy, $467,000 with the plan. Defense offer $45,000. Case settled before mediation at $405,000, 8 months post-demand letter, and it was settled at 9 times the defense offer. The next one, 500,000 policy, slip and fall, 234,000 life care plan, counter offer 20 grand, settled in mediation 6 months post demand, 10 times the defense offer. Last PI case, $1 million policy, 917,000 life care plan, 50,000 defense offer. Case settled in mediation for $785,000, 6 months post-demand, 15 times the defense offer. Now, on the 3 catastrophic cases below at the bottom, the attorneys would probably have gotten life care plans anyway, just later on probably than what we're able to do here because there's no cash outlay. By using earlier in this case, can push the adjusters to raise the reserves and settle much sooner. Now, if you look at the ratios of how many times the defense offer these cases were settled at, for the non-catastrophic cases, it was an average of about 10 times the defense offer, leading to about $1.6 million in additional settlements, with $550,000 or so going into the attorney's pocket as a result. The catastrophic cases only settled for about 3 times the initial offer, typically 12 months post-demand. Again, on those cases, the defense knew they were going to have to pay some money, and they were more realistic at the start, so that ratio went down fairly significantly. But at the end of the day here, again, it's about nearly $11 million in additional settlements with $3.5 million in additional legal fees as a result of these 8 cases and using the life care plans. Now, I'm not going to say that if no life care plans were used, the attorneys wouldn't have gotten more than the defense offer. Of course, they would have. But this really helps to substantially escalate the offers and the settlements in these cases. And I think your intuition tells you that life care plans bring about settlements, and you get more money. It's just how often do you use them is the question. Now let's talk about the lien underwriting and funding process. Attorneys simply apply to our funder describing their case, the coverage, insurers, the theory of liability and damages with some documentation. The case viability is verified with contract following 1 to 3 days, usually within 1 to 3 days. The life care planning team requests all the records, an interview with the client, and discussion with the treating physicians. The life care plan is prepared by the testifying life care planning expert who's promptly paid by our funder. The expert in no way works on any kind of contingency, which of course is unethical, and generally the plan is prepared on average 4 to 8 weeks after the application, although sooner if necessary. Should testimony be necessary, the attorney pays the expert directly their customary testifying fee, typically $4,000 or so, and the expert will typically visit the plaintiff pre-testimony, of course. Upon settlement, the funder is paid $7,500. It's a flat fee. There's no interest involved here. On non-catastrophic cases, it's $15,000. Non-catastrophic it's $7,500, catastrophic $15,000, and the funding here is risk-free. If you lose the case, you owe us nothing. The life care plan's on us. Here you can see the application form where you just fill in your name, type of case status and litigation, etc. There's a little more involved to it than this, but it's very simple. It takes probably 10, 15 minutes. Now, we also offer vocational and economist reports on a lien as well. With the vocational ones, they anticipate the length of the rehab, the handicaps, the impact on placement and range of jobs available, along with the rehab plan. The economist reports provide present value calculations for past lost earnings and benefits, past and future lost earning capacity, past and future lost household services, other possible losses not considered. And the economic report supports the life care plan and vocational reports through economic and financial modeling, and they both cost $4,750 on a lien. Now, with life care plans on a lien, attorneys need no longer leave money on the table. For the first time, you can extend life care plans, both cash and risk-free, to deserving catastrophic and non-catastrophic cases, maximizing the settlements and the firm profit. Now, before we go to an open Q&A, I'd like to ask Linda a few questions.
Hi, go ahead.
Hi, Linda. First of all, does the life care planner communicate with the attorneys before preparing the report? Go through that, please.
Yes. Once we get the referral, we have people reach out to the firm, introduce ourselves, collect the records. They will send our release form, and any other questions will be answered, and any other documentation that we need is sent. Then, as we go through the case and go through the records, if we need anything additional, we reach out to the attorney. We try to keep in communication as much as we can, so we collect the information we need and prepare the plan so that they're happy and satisfied.
Now, Linda, what can you do if in a situation, probably many of you out there have been in this situation, where the plaintiff's treaters are uncooperative and won't provide input into the future care needs?
We encounter that a lot, and that's our first step. Life care planning does have standards of practice, so we adhere to them as closely as we possibly can. So the first step is always the treating physicians or any of the treatment team, and if they don't cooperate, we then try to find an IME physician or something in the pile of records that a physician actually saw and examined this person. And in the absence of that, we have to rely upon clinical practice guidelines.
Now, Linda, are last question to you. Are life care plans used for purposes other than personal injury litigation?
Yes, they are. They're used for estate planning. They're used in divorce litigation. I've done them for private families. They're done for trust setting, to set up trust funds. That's about the most common uses.
Okay. Now, before we open the floor for other questions of Linda or myself, I wanted to let everybody know that a link of this recorded webinar will be available for you or colleagues who are unable to attend. So just give us a call or email us, and we'll be glad to forward the webinar to you. All right, now we'll take questions. Anybody have any? Any questions? Hold on. All right, one question is, what do you find as the most common attack by insurance companies on life care plans? Linda, I'll turf that over to you. Linda?
Can you hear me now?
Yeah,
okay.
Go ahead.
The most common attack is the items in the plan that have the most dollar value, which is usually the home care and therapy. And that's why it's really important to reach out and get cooperation from some kind of treating physician or some medical doctor, especially for the therapy. But there are clinical practice guidelines that enable us to recommend certain amounts as an allowance, because we're recognizing that this client needs this, but yet we're not stepping outside our scope of our practice by playing doctor. That's very important that we make sure we handle that in a way that makes them best.
Yeah, are there any other questions? We have a question over here. All right, one question is, if the case goes to trial, are there additional fees for the testifying expert? Well, typically it's the $4,000 a day plus expenses. That's typically it. It's a flat fee. We like people to know what they're paying in advance. Another question is, will the life care planner withstand cross-examination, qualifications, experience, testimony, experience, versus the defense life care planning expert? Linda, you want to handle that one?
Yes, well, our life care plans are prepared by board-certified life care planners, which the process has met all the Daubert challenges, and if done correctly, will stand up in court, as they have been for years.
Another comment is, our one or two of our folks have a fair amount of defense background as well. They've done defense testimony with life care plans, so they're not just viewed as plaintiffs' experts. All right, do we have any other questions? What is one person asked, what is the typical turnaround time? Well, I'd like to say as fast as you need it done, but part of that depends on you. We need to get all the medical records, interview your client, and try to speak with the treaters, so that can hold things up. We try to turn the cases around or the plans around within 4 to 8 weeks of your application, often sooner. but a lot of that turnaround depends upon how quickly you get us what we need to prepare the report. Another question is, if we know the case is going to trial versus one we want to settle, do you have an opinion on whether to hire a life care planner on a lien versus the usual way? Well, in that situation, if you've got a life care planner that you've been working with for many years that you like very, very much, and it's a multi-million-dollar case, maybe in that situation it's worth spending the money to bring in your own life care planner if that makes you more comfortable, if the stakes are that great and you need that comfort. I think people are using us initially on a lot of mid-range cases, and I'm starting to see them use us more on the catastrophic cases as well. Now, another question is, we have clients that are afraid of surgery. How can life care plans come in and maximize case in lieu of surgery? Linda, that's yours.
What we would typically do is allocate enough recommendations in the plan that can handle exacerbations and flare-ups. And there's clinical practice guidelines. Of course, we try to get that information from the treating doctor. We'll ask them directly, would they benefit from non-medical intervention? And, if they answer and we have an answer from them, then we could include things that will enable this person to get relief during a period of flare-up. And also, we do put a lot of that stuff in because we try to not over-medicate these clients by sending them directly for narcotics. So that's a question that we ask all the neck and back cases. Would they benefit from non-medical intervention?
Okay. One question is, can the life care lien be reduced in the event settlement is not as large as expected, but going to trial is not in the best interest of the client? Well, we haven't been asked yet to reduce a lien, but, under the right circumstances with disappointing results, we're looking for people to come back to us. So, that's something we would certainly entertain. Now, another question is, how are you defining catastrophic versus non-catastrophic cases? My sense is it's something if it's catastrophic. Basically, somebody's going to need lifelong care. They're not totally independent, whether it's a TBI case, brain damage infant, amputation. Those are the ones, in my mind, that are catastrophic, and everything else is non-catastrophic. Linda, do you have anything to add to that?
No, you covered it.
Okay. Let's see if we have some other questions. All right, here's one. What if new medical information comes to light after the initial life care plan is made? Is there a fee to modify the life care plan? And no, there's not. That happens all the time. Linda, will you care to elaborate?
We will amend the report when we get additional information, and that's something that we pretty much put throughout the plan, that we will reserve the right to amend the report upon receipt of additional information. So, that happens a lot, and if it changes the plan significantly, we modify it.
All right, another question. I have a lot of cases with a $100,000 policy minimum. Is this program appropriate for these types of policies? And the answer is a resounding yes, provided the criteria I articulated before are met. 100,000 plus, continuing medical issues, pain injections, radiofrequency ablation, PT. On all of those cases, life care plans are a strong possibility. And when you speak to your clients, we recommend that you, when you talk to them about this, you say, look, I believe a life care plan can raise the value of this case by at least its value, $7,500, let's say. Typically, it's going to raise the settlement a multiple of that, but when you're selling it to your client, you're just saying, look, we break even if we get $7,500 more with a life care plan. You know and I know that the life care plans are going to bring in a lot more than that. Now, talk about having a lot of these cases. We've had clients who we've told to go through their portfolio of cases and just send us applications so that, we could start the process and tell them which cases are viable or not for life care plans. We have no interest in having you sign up for our service on iffy cases because that hurts our own financial interest. I've had firms that went through their portfolio of cases and sent us 25 cases in a week that they wanted life care plans on, and why not, after you saw that chart I showed you earlier. Now, another question is, how about cases where clients have underlying conditions like rheumatoid arthritis or osteo that can complicate a case? Can life care planning allocate aggravation to the case because of an underlying issue? Linda?
I'm going to take that one. No. What happens is there's a process for life care planning, and we follow it. We would rely upon the treating physician to make that determination. We can't practice outside the scope. We cannot be a doctor. So we would reach out to the doctor to make that determination.
Okay. Now, what if we have high medicals, yet no future treatment needed, nor a surgical recommendation? Are life care plans useful then?
There's always going to be an exacerbation or a flare-up if somebody was injured that significantly. Not every life care plan is going to total out to be, $500,000. We've had life care plans that have only reached $30,000 for future care needs and still produced good results at settlement.
Now, is the next question, is there a benefit for getting a life care plan in cases where permanent injury, future treatment is unclear?
Yeah. Oh, yeah, because there's always going to be something that these clients are going to need that we can identify. We're trained to identify how the disability impacts their ability to function in everyday life. It's not just medical care that we look at. We take the person as a whole and individualize each care plan for your particular client.
Okay, next question. The amount paid to the funder is not a medical damage in the case, correct? Absolutely correct. Of course it isn't. And I don't see any more questions. So no more questions. I'd like to thank you all for your time. And again, I want to remind you, if you want a copy of this webinar, just give us a call or shoot us an email, and we'll send you a recording of it. Thanks again for your time. I really appreciate it.